Hi guys, welcome you all to the fast track batch of drafting, pleading and appearance CS professional group 1, and this is a fast track batch completely in English. So I'm sure that you must be aware that we have already completed all the subjects of CS professional, like the detailed classes of CS professional in Hindi, and then the fast track batch has also been completed in Hindi for all subjects. But now on the students' demand, I've started complete English fast track batches, and we have already done the GMRC, governance, risk management, compliance and ethics in complete English. So Hindi is also available now. English has also been done, and now we have started the another subject, which is drafting. So let's get started with this. But since many of the students have enrolled for drafting, and many have enrolled for GMRC, and many have enrolled for both, so I'll just like to give some of my introduction, being the very first class. So my name, as I said, is CS Shantanu, and I qualified the company secretary examination in the year 2012, and since then I've been teaching for the last 10 years, probably even more than that now. And side by side I'm also working. So I think when you actually see our classes of CS professional and CS executive, you not only get the bookish probably knowledge, but also a lot of practical experience, because I've been working for the last 10 years as well as teaching, currently working within Australian multinational company as the senior manager company secretary. And in this class, when we talk about drafting and we talk about the fast track batch, so I am trying probably to cover each and every topic in this fast track batch, but definitely the explanation will not be very deep because this is fast track, but I can assure you that all the amendments, all the topic whatsoever has been covered in the detailed classes will also be covered in this English fast track batch of drafting. So first, chapter first, we're gonna start judicial and administrative framework, which is the chapter number 1. So this first chapter, that is judicial and administrative framework, really talks about the fact, the process of law making, and how the three structures of the constitution, which is legislative, executive and judiciary, work in coordination with each other to make sure that the laws whatsoever, be it company law or just any other laws, actually are being drafted properly and then implemented properly. So all of this will be discussed in this chapter, and we will also discuss the types of court and the functionality of the court, from where does the case starts and how it actually moves ahead, and then finally to the judgment of the courts. So we're going to discuss a lot of things. As I said, every topic will be covered in the fast track batch, so rest assured. And in case you feel that the speed on which I'm speaking is very fast, so you definitely have an option. Either you're watching this on our mobile app, on the iOS, on the Android, or on the laptop, or just any of the devices, you do have the option to control the voice, like the speed. So you can definitely use that option as well. Okay, so first chapter first, this judicial administrative talks about the fact that law has been a very basic requirement for any economy, and legislative, the arm of the constitution, really talks about the formation or the drafting of the laws. So legislative actually deals in that area, and thereafter executive make sure that whatsoever has been left in the legislative side, executive does try and fulfill that role, and finally judiciary makes sure that the laws actually gets fulfilled, otherwise judiciary actually levies fine and penalty towards that. So when we talk all about this, as you all know, that the parliament where the laws are being made does not sit throughout the year. Like there are various sessions, winter session, monsoon session, etc., so on and so forth. You must have heard all of these terms in the news as well. So parliament is not available 24/7, but definitely the requirement for the new laws, or the requirement for the new legislative side of things keeps on coming throughout the year, and it really is something which cannot be predicted. So when the parliament is not in function, probably parliament actually delegates the power, and the powers are being delegated to the executive to actually frame the laws. So all this has been written because in this particular point of time, as I said, obviously lawmaking first of all is not an easy exercise. It does takes a lot of time. I mean, if I tell you like a basic process, so the law first, probably a draft or a bill is being prepared, then it gets presented to the houses of the parliament. after discussion, deliberation, debate, etc. on that bill, it gets passed in one house and probably moves to the other one, and then finally president actually signs that particular bill, and that way the bill becomes an act and probably applicable to the all over India, or as the case may be, as mentioned in the act. So this process is not an easy process, because sometimes it takes months, while sometimes it takes years, and sometimes even after passing of the bill in the houses, it does not get the president's signature and does get lapse as well. So all of this probably is a stage of lawmaking. So all we wanted to convey at this particular point of time is that lawmaking is not a simple task. It probably invites a lot of things need to be discussed and considered before a law is actually get framed or probably gets drafted. So as I was saying, that the parliament is not available 24/7 into 365. So the parliament actually delegates the power. The parliament delegates legislative power to the executive and the executive. So legislative, executive and judiciary, the three arms. So when the parliament is not in functioning, it delegates its power to the executive, and then executive actually try and formulate the law. There are obviously some limitation which executive needs to make sure that they abide or they follow. Otherwise, judiciary definitely have the right to intervene and declare any law as void ab initio or totally void altogether. So I think when we talk about delegation, we are just trying to make sure that the work does not suffer, and probably the executive is well aware of their powers and function within the powers. Now, if we talk about the delegation, then particularly there are two types of delegation. One is skeleton, the other is machine delegation. Skeleton delegation is like probably a lot of powers are being transferred from legislative to executive, which is not the case always. While the second one, which is machinery delegation, is like a routine delegation that happens most of the time with most of the laws. So when we talk about machine delegation, all the basic things probably which a law should have, and probably that needs to be considered before framing a law, the executive has the right to actually make the rules in that particular area and get it implemented, because there are few things which probably legislature will not encounter or probably will not consider while making the law. They may forget, or probably they know that the executive is still there, and executive can make sure that if there's any kind of a lacuna or shortcoming in the law, they can definitely fulfill the same. In regard to the delegated authority, it says that before a law actually gets framed, it actually passes through various stages. The stakeholders. First, as a stakeholder, you must have actually came across this particular word. So when a law is to be framed, the views of the public or the general stakeholder, whosoever is going to be affected by that, are definitely being taken into account and definitely being considered. Like the best example that I can give to you at this particular point of time is the ICSI news labels. So when the news labels which has not been implemented, although this itself is a news labels at this particular point of time, but then the talks are on that there will be a news labels which will be probably there in 2023. Now I cannot really assure whether June or December or probably in 2024. I cannot say, but yes, a proposed syllabus is there on the ICSI website, which you can even look for yourself. And there was a date and a time by which the stakeholders need to give their comments or probably suggestions on that. And likewise, that will be considered, and probably ICSI panel will discuss that and forward it to MCA, and then all those things will happen, and finally something will be brought in front of us. And it is not necessary that those suggestions that you or I or anybody else has given will be there or not. It will be considered for sure, but whether the suggestion will find a place in the final draft or not, we cannot really say. So when we talk about requirements, before any law actually gets framed, the views of the stakeholders have been taken into account. A lot of publicity is being done to the general public so that they can also present their views if there's any. And probably once everybody's views has been submitted, then only the draft is being prepared to make sure that, wherever possible, we try and involve most of the stakeholders that we can. Moving forward, we talk about the modes of control of delegated legislation. So as I said that the parliament, as you even yourself know, the parliament does not sit in power throughout the year, and it works in various sessions. And when the parliament is not in session, the powers are being delegated to the executive to make sure that the work runs smoothly and probably there's no backlog or there's no issues as such. But if the executive tries to actually override the power or probably make misuse of the powers, then there are few checks and limitations that can be done on that. So it says that the delegated legislation can be controlled or probably checked by three ways. One is procedural, the other is parliamentary, and the third is judicial. Procedural really talks about the fact that whenever any law is being framed or probably any rules or regulations are being driven by or being formed by the executive, they need to make sure that they follow the process as set by the specified committee or as per the law. The executive should definitely keep this in mind that the powers have been delegated to them to make the laws or to frame the laws, and they have to abide by that. They cannot overrule or override the process. They have to move step by step according to the process. The other is parliamentary. The parliamentary method of control is like in case there's any over exercise of powers or probably misuse of any kind of delegation to the powers that has been given to the executive, the parliament or the legislature can step in and probably discard all the rules and regulation that has been made by the executive using the delegated legislation. So all we are trying is to make sure that executive functions, but it functions for the betterment of the society, for the betterment of the community, for the betterment of the stakeholders. It should not, the executive should not make any kind of misuse of the powers. They should always and always try to function within the capacity or the delegation limits that have been sanctioned to them. The third thing that we can consider here is the judicial control, because the judicial control probably is something that is exercised by the courts. So, I mean, if the law has been framed and implemented, but still, if somebody challenges that law in the court of law, and the law finds, or the court finds, the honorable court finds that the law is unconstitutional and does not serve the purpose, or probably the objective for which the law has been framed are not getting fulfilled, then the judiciary definitely has the power to probably declare the law as void ab initio. But you see, in the practical life, I mean, I'm not sure how much historical perspective you are aware of, but if you see, there was lots and lots of things about CAA, which is Citizenship Act. I mean, if you know about that. And then there was a lot of probably agitation going on in and around Delhi and other parts of the India regarding the farmer laws. But you see, the courts really did intervene. They kept on hearing the things as to what was said, but finally the government itself rolled back the law. I mean, the judiciary definitely has the power to intervene and roll back the law that has been already passed by the parliament. But the judiciary will not intervene unless it is the only option left. So judiciary does have the power, but they'll not try and interfere with the legislative and the executive side. But definitely, if they think that the legislature or executive is going beyond the capacity or going beyond the law, and clearly, as we all know, nobody is above law, then definitely judiciary will intervene. But that is a very last step, which in the history has happened very, very often, and it's not a customary thing. Moving forward, if we talk about the facts in regard to the tribunals, so as you all know, the courts in India or throughout the world, and especially in India, recently I suppose we had a kind of World Population Day, and in that United Nations clearly said that obviously apart from China or next to China, India is the most populated country in the world, as we all know. But in 2023, probably India will overtake China in terms of the population. So will be the first largest populated country in the world if this particular report of UN is correct, which is really alarming because I've heard somewhere that the courts cases, because the more people we have in a country, the more are the problems that are associated with that. Be it employment, be it food, be it judiciary, just like various things, right? So it's not the essential thing that we should control the population, but on the same side, if we talk about the judicial burden, that is also getting increased day by day. It is being said that at this particular point of time, the lower court has about 30 lakh cases pending, and some of them probably there are various cases in high court and lower court that have been pending for more than 10 years. And I've heard somewhere saying that in a particular court, a judge in this particular point of time while I'm speaking to you takes care about probably 100 cases a day, and you can yourself imagine how much time one case will deserve if a judge is actually being burdened with 100 cases a day. So I think it's very important, and has been the need now to set up the tribunal or the fast track court to dispose of the matter as soon as possible, because we all know it does not really matter what kind of law it is, but we all know that the purpose of law is to provide justice, and then I think we have heard many times that justice delayed is justice denied. So tribunal are various types, and tribunals are probably quasi-judicial body that have been set up to speed disposal of the matters. We have a lot of tribunal functioning in the country, be it income tax or National Company Law Tribunal or SAD and various others. Talking about DRT, which is Debt Recovery Tribunal, is probably the one where probably people take, the companies take a lot of loan from the banks and the financial institution, and then they don't return the amount, and probably there comes a DRT where the execution application can be filed and the court cases can move forward. Otherwise, all these cases will also go to the civil case, civil court, and then probably high court. So civil and high court really has a lot of other cases as well. So just to probably streamline the type of cases, specified tribunals have been formed. So those cases which belong to that particular field goes to that particular tribunal. Like if we are talking about the company law side of things, we have NCLT. If we talk about the Competition Act, we have Compact. If we talk about the security market, we have SAD. So it is not like the civil or the High Court or the Supreme Court cannot hear these cases. Definitely they can. But they have so many other routine cases that probably very little time is left with them to actually hear and decide on these matters. As a result of that, these cases have been pending for long, and as I said, probably more than 10 years, 15 years. And if the case has been pending for this long, you can imagine for yourself that probably the possibility of getting justice, or probably the possibility of finding the offender or the culprit really is zero, because so much time has elapsed, and with the passage of time probably the evidence also get destroyed and so many other things. So the tribunals have been set up to make sure that the work actually becomes easy and the work gets divided. We also have consumer forum or the consumer tribunal to make sure that the interest of the consumer stays protected all the time. In case there's any kind of an accident, so to claim the compensation, or probably if somebody has died, to claim the compensation for the death, the motor accident claim tribunal can be approached. Similarly, if there's any hearing of the staff members of the central government, then definitely central administrative tribunal can be approached on that area. You must have actually heard a lot of time about NGT, which is National Green Tribunal. So a lot of cases of pollutions, probably pollution does not mean only the air pollution, but noise pollution, soil pollution has been emerging, and we all know about climate change and all those things and the effect of climate change in and around us. So NGT definitely plays a very good role in that area. So NGT deals with all the cases related to the environment. In regard to the types of court, we have civil and the criminal courts that definitely deals with the matter depending upon the cause of action or probably the type of the case. Now, what is civil and what is criminal is very simple thing. I'll just give you an example. For example, if there's a dispute related to a property, then this particular thing can be dealt under the civil side of laws. But if there has been a case of fraud, robbery, murder, etc., the serious offense kind of things obviously are the nature of the criminal court. So there are few cases where probably both angle will be inspected, the civil and the criminal, but this is like the way how you differentiate between these two. Then comes the Supreme Court. As we all know, Supreme Court is the highest court of the land, and all the courts in India actually function under the Supreme Court. Supreme Court is the apex court or the highest court, and nobody probably will get the right to actually go directly to the Supreme Court unless there are exception to the rule. So obviously you'll start from the lower court and probably move to the higher court. And if you must have heard about two things, the question of law and the question of fact. So if your case actually is fall within these kinds of things, the question of law or the question of fact, you can go to the High Court and Supreme Court. But there are very limited cases which actually go directly to the Supreme Court, because if the Supreme Court is the only court which need to decide the cases, and what is the use of the lower court, what is the use of these district court and civil and criminal court. So the case starts with the lower courts, and if the case really has a substance, and if you think that justice has not been served, definitely you have the right to approach to the higher courts. Now the High Court in India really functions a lot and probably help the individuals to enforce their fundamental rights and also control the courts in the territory or in the states, because the high courts are being driven generally by a state, while district court, as the name suggests, is for a district, and district court will be set up depending upon the population and the grievances and the offense side of things, and district court is something that is being administered by the state governments. So lower courts in India, as I said, district court is actually the one that has been set up by the state governments, and they actually have two domains. One is civil and the other is criminal, and depending upon the type of cases, the case actually either lands up on the civil or the criminal side of things. Now the district judge also has been empowered to actually deal the civil and the criminal cases both. Depending upon the case availability and the workload, this can be decided. Now there are revenue courts as well, which talks about or deals with the matter related to the dispute for stamp duty registration. So these are the things that revenue court actually decide. Now we'll talk about the process of the civil court, how a case actually gets started, and then how it actually goes forward, and finally what is the judgment, and then how it is executed. All of these things have been divided into various stages. The one of them, or the first, is called as jurisdiction. So the first step in the working of the civil court is jurisdiction. Like if there is any kind of a dispute, and if it is obviously a civil nature dispute, then first we have to decide which civil court do we need to approach, because there are various factors actually which will decide or which will help us to determine which court really has a jurisdiction. So we need to decide this on the basis of where the cause of action has arises, and probably the amount of money that is involved in that case. So accordingly, first the jurisdiction has been decided. Once the jurisdiction is decided, then probably the second thing is stay orders, because it may be the fact that the suit or the case is between various parties. Some actually reside in North India, while some in West and South and then East. So everybody is trying to file or institute a case, or probably a court of law, going to the court of law to make sure that this particular case does not actually start in 10 courts or probably more than that. We need to make sure that we actually say to the court that all the other cases that are being going under any of the district courts should be stayed or should be actually put on hold, and only one proceeding should start, because otherwise different courts will probably do the different things, and different documents will be asked and probably land up in different judgment as well. So to make sure that does not happen, the stay is also one of the options. Then we have res judicata, which means whatever has been decided, because sometimes the people or the parties actually who are actually in front of each other in form of dispute, they actually don't agree with what the court has been decided and keep on filing appeals, but probably don't understand the law. So probably the court can say that this is the final judgment and no further appeals can be entertained after that. Plaint is the fact where the case actually starts, because plaint is a kind of a document where you put the allegations on the other party. So there are two parties, as an example, called as A and then called as B. So A filed a plaint, and in this plaint A will actually make up the allegations against B, that B has done this or B hasn't done this, which he or she was supposed to do that. So plaint is the document which put the judicial system in action. And then once the plaint has been filed by A, the court will issue summon and invite B, or as the case may be, the other parties to the court, and probably a date will be fixed where the party will be asked to actually visit the court, or probably send their advocates to the court, and probably from there the questions rounds and probably the cause of action will be examined, and this will be moved forward. So the party will appear, and in case the party cannot appear, they can ask the court to actually do the adjournment. Adjournment means that this case will be heard in some next date, so that can be adjourned. You must have, there's a very famous dialogue in Bollywood by the actor called as Sunny Deol, called as Tariq pe Tariq, Tariq pe Tariq. That means adjournment only. And if after repeated adjournment the parties, one of the two parties really does not get present, or the defendant does not get present itself to the court of law, the court can pass an ex parte order, meaning that the defendant has nothing to say, and whatever the plaintiff has said is correct, and court will just decide the case on whatever plaintiff has probably provided, because defendant was asked to come to the court and provide the documents, but he didn't came and neither provided any sufficient reason. So whatever is there in front of the court will decide the matters on that basis only. Then we have injunctions. So in case the plaintiff or the defendant, so who are plaintiff and defendant? So there are two parties, as I just said. This is just an example. If A has filed a case on B, so A will call himself as the plaintiff and B will be called as a defendant. The reason being that B is defending, right? So A has put in allegations on B, and B will defend, no, I have not done this, or I have done this, as the case may be. So the person who filed the case is called as plaintiff, and against whom that is being filed is called as a defendant. So either of the party can also ask the court that the case will go on, or the case can go on, but the parties can request the court to put an injunction like the stay order, so that during the pendency of the case, or during the time the case is getting heard, no change needs to be made to any of the cause of action thing or any of the structure side of things. So written statement is the reply to the plaint. So as I mentioned above, A has put in some allegations against B, and then B will reply to all those allegations, and the reply of B will be given in the form of written statement. So when A put the allegations in the name of B, A will prepare a document called as plaint, and then B will give the reply to that all that allegation that probably A has revealed on B. So B will give the reply, and the document will be called as a written statement, in which B will reply to A, or probably B will actually put the counter allegations to A. So A will actually put the allegation in the document called as plaint in the name of B, and then B will reply to all those things, and then that particular document will be called as a written statement. Now the parties will be heard, and the documents will be produced, and if required the witness will be called. The court will also examine the issue, because once the documents have been filed, A said I have this and this problem with B, and then B will reply that this etc. Then after providing all the documents, both the parties will be heard in the court. In the court of law, the judge will decide, the honorable judge will decide that this is the reason of the dispute, this is the point on which the dispute has arisen, and that particular point will be taken, and then probably parties will be heard. Because I think the most important thing when two or more than two people are arguing, first of all, I think the most important thing is to determine the reason of that argument, right? So when we talk about the reason of argument, we are talking about the framing of issues. So if required, the witness can also be called, and if there are few things which the parties are claiming that they have done it or they haven't done it, but they don't have any documentary evidence, so they can just write that on a stamp paper, which is also called as an affidavit. And as we move ahead in this particular course, we will also do the practice to the extent possible in this fast track batch on how to write an affidavit and how to probably write a plaint or a written statement. So after hearing all the the arguments to and against between the parties, final date will be decided, that this is the date on which the parties need to actually present the final version that they have, or anything that they have to add to that case. And after hearing all those things, the court will definitely decide a date on which they will pass the judgment. And once the judgment has been passed, then probably it will get to the execution. For example, if the case was between A and B, then it was decided that B will now pay 5 lakh rupees to A. So this is the judgment, and now B will be given a time of, let's say, 15 days, 30 days, that within this and this time B has to execute, B has to pay this amount to A and inform the court. So this is called as the execution area. So this is how the system of the civil code really works, and this is a step-by-step approach by which a civil code actually gets function. Now we also have the types of criminal courts. So obviously there is one thing called as summon and the other called as warrant. So we'll discuss that one by one. So it says that